This will be the beginning of the deposition of Debra Fountain. It is January 10th, 2018. The time is 10:11 a.m. and we're on the record. This is a case of Jesse Williams versus Grand Traverse County for the state of Michigan in the 13th Circuit Court, case number 1732326CZ. Now the attorneys will identify themselves and whom they represent, and the court reporter will swear in the witness.
Josh Blanchard on behalf of the plaintiff, Jesse Williams.
Greg Grant for the defendant.
Ms. Fountain, would you raise your right hand, please? Do solemnly swear or affirm the testimony you're about to give shall be nothing but the whole truth?
I will.
Thank you. Ms. Fountain.
Wait, let me place an objection, I guess, Josh, before we go. A couple of objections. Number one, present at today's deposition is Mr. Eric Van Duzen, who is not a party to this case. I have been told that he is here to simply make an audio recording. We would object to the redundancy of him being here in light of the fact that this deposition is also being recorded by video. Nothing allows him to be here as a non-party. For purposes of moving on today, we'll allow it. But my objection's noted. The other objection would be my clients are here to answer questions about the FOIA case only. The allegations made in the FOIA complaint, they're not here to answer any questions relative to any potential liability, Section 1983 civil rights case. So if you do get into any areas that aren't relative to this case, my clients aren't going to be answering that.
You can instruct your client not to answer any questions you want.
I will.
And if you're wrong, we'll take it up with the judge.
We will.
Very well. Anything else you want to put on the record before we start, Mr. Grant?
That's it.
Very well. Good morning. I think I introduced myself off the record, but I'm Josh Blanchard. I'm an attorney. I represent Mr. Williams in this case. Can you tell me your full name, please?
Debra Ann Fountain.
And how do you spell Debra?
Debra.
And Fountain?
Fountain.
I want to talk to you about depositions generally. Have you ever given a deposition before?
No.
Okay. So what's going to happen is I'm going to ask you some questions, and I expect you to answer the questions unless your lawyer tells you not to answer it. Do you understand that?
I do.
And he may place objections on the record. When he does that, after he's done with his objection, unless he tells you not to answer the question, you still have to answer the question. Do you understand that?
I do.
Okay. If you answer a question that I've asked, I'm going to assume that you heard the question and understood it, okay?
Yes.
Is that fair?
Yes.
If you don't understand a question or don't hear me clearly, would you let me know that?
Yes.
All right. You work for the Grand Traverse County Sheriff's Office, is that true?
Yes.
What is your job there?
I'm the FOIA coordinator.
Is that a full-time or part-time job?
Full-time.
What are your job duties as the FOIA coordinator for the Grand Traverse County Sheriff's Office?
To receive the FOIA requests for the Sheriff's Office and the Traverse City Police Department, to determine if it's information we maintain, process the information, and return it to the requester.
Okay, now when you say process the information, what does that mean?
To gather what I'm able to gather and provide what they're requesting.
So you always provide what's requested?
If it's available within the FOIA rules.
Okay. You say within the FOIA rules, do you mean information that you don't believe to be exempt?
Subject to the form. If you understood the question.
I'm not sure that I did.
Do you make the determination of whether information that is requested pursuant to FOIA should be exempted under the FOIA exemptions?
For most things, but I do seek assistance from administration.
So sometimes you make the decision, sometimes you seek input from your superiors.
Correct.
And who are the people that you have sought input from in the past?
Chris Forsythe of the Prosecuting Attorney's Office.
Okay. Who else?
Under Sheriff Elger. If it's a matter pertaining to the Grand Traverse County Jail, then Captain Ritter. If it's the City of Traverse City, certainly Chief O'Brien.
Okay. And you're familiar with a FOIA request in this case, correct?
Yes.
that was made by Mr. Williams for certain documents related to the death of Mr. Holloway?
Yes.
Okay. Who did you consult with in this case, if anyone, in determining how to respond?
Chris Forsyth of the Prosecuting Attorney's Office, under Sheriff Elger, Captain Ritter, Lieutenant Lassa of the jail, Captain Fulis of our Investigative Services Division. I believe that's all.
So you said there was a lieutenant at the jail that you consulted with?
Yes.
And a captain from the Investigative Services Division that you consulted with? Is that a yes?
Yes.
We're making a audio, and we can see the head nodding on
Yes.
the video, but in the transcript, a head nod doesn't show up, so I need a verbal answer. Thank you. Had you ever, prior to this FOIA request, consulted with a captain from the Investigative Services Division or the lieutenant from the jail on how to respond to a FOIA request?
I'm going to object just to the form and the foundation. You can answer if you can.
I have consulted them on other occasions.
How long have you been the FOIA coordinator for the Grand Traverse County Sheriff's Office?
Since March of 2015.
Over that time period, approximately, how many FOIA requests have you responded to?
Oh. Sometimes we do 40 a week. Sometimes we'll do more or less. So
Is 40 a pretty standard volume in a week?
I would say so, yes.
Fair to say then you've handled hundreds or thousands of FOIA requests?
Sure.
Tell me about your educational background. Did you graduate from high school?
Yes.
Where did you graduate from high school?
Elma High School.
Did you go to college?
I have some college.
Where at?
Alpena Community College,
What did you study at Alpena Community College?
business.
Did you obtain a degree there?
No.
Did you go to college anywhere other than at Alpena Community College?
I've taken classes at several colleges, but no degree.
Okay. What kinds of classes have you taken?
Business, medical, accounting.
Okay. Have you had any training specific to the Michigan Freedom of Information Act?
I had training from the administration at the Sheriff's Office when I began in March of 2015. I've attended training from CMDA. I've attended their FOIA training. The Grand Traverse County Prosecutor's Office also has a county-wide FOIA training that I've attended, and the Michigan State Police FOIA training.
I think everyone in the room knows, but when you're saying FOIA, you're referring to the Freedom of Information Act, correct?
Correct.
All right. When was the last time you did training related to FOIA?
It was in 2017,
And what was that?
the Michigan State Police program.
So you received, on behalf of the Grand Traverse County Sheriff's Office, a FOIA request from Jesse Williams dated August 16 of 2017. Is that correct?
I'm not certain of the date, but I believe it was near that date.
Would it refresh your recollection to look at a copy of it?
Sure.
I'm showing you what's Exhibit 1 to the complaint in this matter.
Yes, it's dated August 16, 2017.
And you received that sometime shortly after August 16 of 2017?
Yes.
You issued a response to that, correct?
Yes.
And you issued that response on September 8 of 2017, correct?
I'm not certain of the date, but I believe so. September 8th, 2017.
In between receipt of Mr. Williams' FOIA request on August 16, 2017, and your response on September 8, what did you do in order to respond to it?
The request was reviewed, and it pertained to the jail, so a copy was sent to Captain Ritter and Lieutenant Lassa at the jail. They began to gather the information. Most of that information is something that would be available to them over there. They were certainly aware of their records and what was available. They brought that information to me, and it was reviewed and processed.
So I want to talk to you about the information they obtained and brought to you. Did they only bring to you the items that were ultimately disclosed to Mr. Williams, or did they bring you those items plus the items that were withheld?
They brought everything. They brought some of the item, or all of the items that were withheld as well.
Okay, so you received all of the documents that were responsive to Mr. Williams' request that existed, you received prior to issuing the September 8, 2017 response.
Yes,
And then you reviewed them before issuing the response, correct?
correct.
Did Lieutenant, is it Lassa?
Yes.
How do you spell that?
Lassa.
Did Lieutenant Lassa or Captain Ritter provide you direction on which items to release or which items to exempt or withhold?
Yes.
Who provided you that direction?
Actually, I should say they provided their concerns about some things. It was what they felt they had concerns about.
In what way did they provide you those concerns?
Verbally, we had a meeting regarding that.
A face-to-face?
Yes.
How often do you have face-to-face meetings with Lieutenant Lassa or Captain Ritter regarding their concerns about a Freedom of Information Act request?
Often. Probably every one that comes in, we meet.
Which one of the two of them did you meet with, or was it both?
I met with them both at the same time.
What concerns did Lieutenant Lassa express to you?
He was concerned about the security of the jail as it pertained to some of the photographs that were there, a floor plan diagram. They were concerned, pardon me, they were concerned about other inmates' information and their privacy. And I believe those were the two major items.
Did they express to you any concern about a potential wrongful death lawsuit being filed against the sheriff, the county, or the jail?
No,
Did they express any concern about criminal liability for what had happened in the jail?
no,
After you issued your September 8, 2017 response, are you aware that Mr. Williams filed an administrative appeal
yes,
on or about September 13,
I believe so.
and that was responded to by Under Sheriff Nathan Alger on or about September 21?
Yes,
Have you seen a copy of Under Sheriff Alger's response to Mr. Williams' administrative appeal?
yes.
Prior to coming here to testify today, what did you do to prepare?
I reviewed the exhibits that you provided.
When you say the exhibits that I provided, what are you talking about?
The packet that you just are showing me with the my response in it, the appeal letter, the request, those items.
Any other items?
There were some other documents included. I'm not sure where they came from, I believe, but they were included in the exhibit file.
What were the documents that you reviewed?
I believe it was some photographs of the jail and a floor plan, some other items, that's all I can recall.
They were your exhibits, your client's exhibits.
Not to the complaint. You're saying the
The exhibits that you filed 2 days ago.
thank you. You reviewed those apparently with Mr. Grant.
I did.
Did you speak with anyone other than Mr. Grant about your testimony or the deposition testimony that you're giving today?
There were others that are aware that I'm here doing this, but not in detail.
Did you talk to the sheriff or undersheriff about today?
Not in detail, no.
So, as I understand the process, you received documents from the jail, you reviewed them, you received input from from Lieutenant Lassa and Captain Ritter, and then you made the decision?
No. When they brought the documents to me, I held on to them, and we met as an administrative group.
Let me interrupt you for a moment. When you say you met as an administrative group, who was involved in that meeting?
Under Sheriff Elger, Captain Ritter, Lieutenant Lassa, myself. I believe Captain Fulis was there as well. And we talked about the material that was provided.
And what day did that occur on?
I don't know. I can look at some notes, but I don't have them with me.
Okay. Fair to say it occurred on or before September 8, 2017?
Oh, yes.
Did you only have one of these meetings?
I believe we only had one meeting to discuss what everyone's concern was.
At the conclusion of that meeting, was a decision reached about what the response would be?
No.
When was a decision reached?
After that meeting, we met with Chris Forsyth of the prosecuting attorney's office and discussed the concerns with him. And after that, we made a decision.
When you say we, who is the we?
Chris Forsyth, Under Sheriff Elger, myself, Captain Fulis. I believe Captain Ritter was there, Lieutenant Lassa, and I believe the sheriff was there for that meeting.
So you had a meeting without the sheriff and without Mr. Forsyth where you discussed this, and then later you had another meeting with the sheriff, Mr. Forsyth, and the rest of the administrative group? Okay. Was a conclusion reached at the meeting that involved Mr. Forsyth?
Yes.
Who made the decision?
Mr. Forsyth and Under Sheriff Elger.
So Mr. Forsyth made the decision on what to release and what not to release?
Yes, we discussed our concerns about personal information and other things going out, and he upheld our concerns, and then the decision was made.
And it's your understanding or your impression that the decision, you expressed your concerns and then the decision was made by Mr. Forsyth?
Yes.
And so there was an exhibit or a continuation to your FOIA denial that had 3 numbered paragraphs on it. Do you recall that?
I do.
Who drafted that document?
I did.
Where did you get the information that you included in that?
Which information are you referring to?
Well, so for example, you cited 2 different statutes. How did you determine which statutes to cite to?
I have a copy of the FOIA statute that I use regularly, and in notes from training.
So in this meeting that involved Mr. Forsyth and the sheriff, you didn't resolve which FOIA sections you were going to rely upon to deny? Is that fair?
I believe so, yes.
So you determined at that meeting to deny parts of the request, but you didn't determine at the meeting on which statutory basis to deny it?
I believe it was understood by me that if it was personal information, it would be under the personal information exemption.
Okay. So there were several bases on which you denied parts of Mr. Williams' request, correct?
Correct.
One of those bases was compelled officer interviews, correct?
Yes.
Those are what we commonly call Garrity interviews, correct?
Right.
And then we had something that you called an officer Loudermill hearing, correct?
Yes.
That's what you were trying to reference there was the termination hearings and interviews for the deputies, correct? The corrections deputies?
Yes.
Then you cited to information compromising the security of the jail,
Yes.
to attorney-client privilege.
Just object to the form of that.
I'll rephrase it. You exempted from disclosure certain items based on information or records subject to the attorney-client privilege, correct?
Yes.
Similarly, you exempted from disclosure certain items, information or records reflecting frank communications within a public body of an advisory nature, correct?
Yes.
Then you also, for those items that I went over, those 5 items I just went over, those you didn't give any part of the record, correct?
I know attorney-client, we did not. Frank communication, I don't believe so.
So let me phrase it this way. In your supplemental response, you had 3 categories. You had categories exempt, you had categories of documents that didn't exist, and then you had categories for which you redacted information. Is that right?
That is right.
And so for the things that you said were exempt, you just didn't provide those at all, correct?
I'm just reviewing them just a moment.
Take your time.
Yes.
And then for the items which you redacted, you provided some information and you didn't provide other information, correct?
Correct.
So you separated the exempt from the non-exempt in those situations.
Correct.
For the compelled officer interviews, what documents did you not provide?
Well, I'm going to object compelled officer interviews. That's not a subject of this lawsuit.
Okay. So for compelled officer interviews, what documents or records did you not provide?
Again,
I understand your
object.
objection. Are you instructing her not to answer the question?
This has nothing to do with the FOIA case.
Are you instructing her not to answer the question?
Well, you can describe the documents to the best of your ability,
No, so
but you can't describe the contents of the documents.
I didn't ask you to describe the contents. I want to know what records did you withhold relating to compelled officer interviews?
You can answer to the extent that you have that knowledge.
They were just statements made by the officers under their Garrity.
How did you know that they were made pursuant to Garrity?
I believe that I knew that because it was discussed with Captain Ritter, and it was also, seems to me like there was a statement that the officers had made.
When you say a statement that
Those
the officers had made, are you talking about a written statement, an oral statement?
A written statement.
Okay. Are we talking about like a written advice of Garrity rights?
I believe so. Yes.
So they were advised in writing that they had certain
Yes.
rights pursuant to Garrity,
Yes,
and you got a written copy of that notice.
correct.
Did you provide a copy of that notice to Mr. Williams in response to his FOIA request?
I believe so.
For the compelled officer interviews, do you know whether those were done at the request of the mission team or some other investigative agency?
I don't know.
When I say the mission team, do you know what I'm talking about?
Yes,
Okay. That's a couple sheriff's detectives from other counties that investigate, sort of like an internal affairs division. Is that fair?
more or less.
Through the Sheriff's Association. Is that right?
As best that I know.
Okay. I'm sorry, I don't, maybe I asked this. How many of these interviews were there?
I don't recall.
Okay. For the Loudermill hearings, what public records did you withhold?
Same objection. It's not part of the case. You can answer if you know.
I don't know.
How do you know that you withheld something then?
I know that it was withheld. I don't know how many there were.
Yeah, I think my question there was what documents were withheld, not how many.
I don't recall that.
Do you know if these were written reports, video recordings, audio recordings?
They were written.
Okay. Do you know who prepared them?
No.
Related to the security of the jail exemption, what public records did you withhold?
Object to the form of the question. Go ahead.
I believe there was a floor plan. There were some photographs. And I believe there was a policy that related to transporting inmates or something like that.
And did you review the floor plan and the photos yourself before issuing the notice of denial?
I did review them.
Regarding attorney-client privilege, what kinds of public records, I'm not asking right now for you to talk to me about the contents, okay? What kinds of public records did you withhold in response to Mr. Williams' request?
Just object to the form of the question. You can answer if you can without describing it.
So that we're clear on the rules here, unless he tells you not to,
Yeah.
you just need to answer the question.
Yes, I'm considering that. I believe it was email
Email with who?
between a Grand Traverse County employee and their attorney.
Okay. Was this employee involved in the FOIA decision process?
Yes.
Who was the employee?
There were some that were for Chris Forsyth, Bob Cooney, Under Sheriff Elger, and that's all I can recall.
So you named there two people that are attorneys, right? You named Bob Cooney and Chris Forsyth, right? Is that a yes?
Yes, sorry.
And then you named one employee of the Sheriff's Department, Nathan Alger, correct?
Yes.
So you're saying that the items that were exempted pursuant to attorney-client privilege were emails between Nathan Alger and either Mr. Cooney or Mr. Forsyth?
In some cases, yes. In some cases, it may have been other attorneys that Under Sheriff Elger would have corresponded with.
Related to this FOIA case?
Not necessarily, but I believe so.
And was this done on the county computer system?
Yes.
Was anyone other than Mr. Alger and his attorneys copied or carbon copied on these emails?
I don't recall.
Were any of the emails involving you?
No.
Other than emails, were there any public records that you withheld relying upon the attorney-client privilege exception?
I don't recall any.
Regarding the frank communication exception or exemption, what kinds of public records did you withhold relying upon that exemption?
I believe there were some emails.
Let me stop you there. So the emails.
Well, wait a minute. Don't interrupt her. Let her finish her answer before you interrupt her.
It's my dep. I'll ask the questions the way I want.
Yeah, but you're not going to interrupt her or we'll terminate the deposition. You know that.
So what kinds of email, or who were the emails between?
Captain Ritter and his employees.
Okay. Were there emails between anyone else?
Not that I recall.
And were these emails from Captain Ritter to his employees?
I think they were both. I think they were received by him and possibly responded to by him.
Okay. So the only thing you exempted under the frank communication exception to FOIA in terms of email were the emails between Ritter and jail deputies.
That's all I can recall.
Were there other public records that you exempted under the frank communication exception other than emails?
I don't recall any.
So to the best of your recollection, the only documents exempted pursuant to the frank communication exception were emails between Captain Ritter and corrections officers at the jail?
Yes.
Because you're claiming an exemption, I don't want you to tell me the contents of those emails, okay?
Okay.
But I do want you to, subject to an objection from your attorney, tell me the subject matter of the emails.
Just to place an objection form foundation. You can answer it if you recall.
I don't recall.
Do you recall whether the emails contained factual discussion about things that had happened at the jail?
I don't believe they did.
Do you recall if they talked about policies or procedures or plans?
I don't recall.
Did you review those before you came today?
I did not.
How did you conclude that the documents were frank communications?
They were reviewed and they were not of factual content.
Tell me what that means, not of a factual content.
Whatever the subject was, it wasn't something that was a policy or something that was a statute or a law or something factual.
Okay.
It was just a conversation.
So what does that mean, a conversation isn't factual? I mean, I'm not sure I understand the distinction you're drawing. Try and help me understand that.
Let's just object to the form vague. You can answer if you understand it.
I don't. It just isn't a fact.
Okay.
It was just a casual conversation.
How do you understand a fact to be defined?
Something that's proved or in place, if it's a policy type thing.
Okay. Can we go off the record for a moment?
Going off the record, the time is 10:44 a.m. Back on the record, the time is 10:45.
You understand you're still under oath, right?
Yes.
With regard to the information that you redacted, you claimed an exemption based on information of a personal nature, including inmate names, addresses, and telephone information, right?
Correct.
For this exemption, other than where in the reports you redacted an inmate's name, telephone number, or address, was there anything else you redacted on that exemption?
For an inmate? Is that your question?
Well, for anyone that you relied on information of a
Okay.
personal nature.
That's all I recall.
When you reference for redactions compelled officer statements, are we again referring to in reports where you redacted a block of an officer statement?
Yes.
How did you determine for those statements that they were compelled?
I believe it was part of the report that it had been, that they had taken their oath.
Then lastly, in your redactions, you indicated camera numbers compromising secured layout of a facility. What does that mean in terms of what you redacted?
We redacted those because it was an identifier and a security risk within the jail.
Yeah, I'm sorry. What I'm trying to get to right now is what in the documents got redacted?
Just object to the extent that the document speaks for itself. Go ahead.
The camera number was redacted.
Okay. And when we say camera number, are we talking about like a numeric identifier for the camera in the corner? It might be called camera 9 or 46 or something like that?
I believe so.
Okay. The things that were redacted weren't the location of cameras, correct?
Not that I recall.
I mean, the reports didn't say there's a camera in the northwest corner of the room 8 feet off the ground. That's not what you redacted, right?
Right.
You just redacted a numeric identifier for the camera.
Correct.
And for that, you relied on information compromising the security of a penal institution, correct?
Yes.
Okay. You previously mentioned that you also refused to disclose a layout of the jail floor plan. Did you reference that anywhere in your notice of denial?
I believe that's issue under the security of the jail.
I'm going to show
that we
you
wouldn't-
the continuation of your notice of denial. What part would put Mr. Williams on notice that you were withholding a floor plan of the jail?
It is not listed on there.
Thank you. And so you didn't disclose to Mr. Williams anywhere that you had withheld a floor plan. Is that correct?
It's not listed on the response.
So let's talk about the exemption regarding security of the jail. When I refer to that, do you understand that I'm talking about the exemption found at MCL 15.2431C?
Yes.
Okay. And you understand that exemption to allow public body to not disclose records where the disclosure would prejudice the public body's ability to maintain the physical security of a penal institution, right?
Correct.
Okay. And you consider the jail to be a penal institution?
Yes.
Okay. For that basis, you referenced the camera numbers and then here today, the jail layout, correct?
Yes.
Were there any other items that you relied upon that basis for?
I believe the photographs also were under that.
Did you disclose that to Mr. Williams in your notice of denial anywhere?
If it's not on that response, we did not.
Well, I want to guess. Is it on the response?
The photographs are not on the response, but I do note that under the redactions, the camera numbers compromising the security is on there.
Correct. The camera numbers
Yes.
is on there, but
Yes.
photographs, videos, floor plan are not, correct? Okay. Prior to denying Mr. Williams' request for the documents that included the camera numbers, what did you do in order to determine that disclosing the camera number would compromise or prejudice the public body's ability to maintain the physical security of the jail?
Maintaining the security of the jail was a high priority for Lieutenant Lassa and Captain Ritter.
Sure.
That was one of their concerns that they brought to me. And when we met as a group, administrative group, we discussed that and we were in agreement to that. We took it to the prosecutor and he felt the same way.
Okay, so that's the conclusions you reached. My question for you is, what did you do to determine that disclosing the numbers would actually prejudice the security of the jail?
I think she answered that in part. She said they had a meeting about it, but you can answer that
We
further
can-
if you want.
We had a meeting about it and during the meeting we discussed that that information being released is a security concern.
Okay. So tell me, how is it a security concern?
Objective foundation. You can answer if you can.
It's subject to whatever anyone would do with that information.
Okay, what could somebody, did you discuss the possible risks of what could be done with that information during these meetings?
I think we all understand that it's a risk that anyone, having ill motives can do whatever they will.
Let me back up. Did you discuss what people could do with the information at these meetings?
No, it was no.
But you say it's understood what people
Yes,
could do. So
yes.
tell me then, what is understood that people could do with the numeric identifiers for cameras?
Just objective foundation. Calls for the witness to speculate.
She just
You can
testified she
answer.
understood it.
Well, let me get my objection out, and then you can respond.
If
and
you'd
then you
stop
can
with
ask
the
your question.
speaking objections, give me foundation, form, whatever you want, but you keep coaching the witness on what to do.
I haven't coached
appreciate
the
it if you-
witness. The objection was foundation. It calls for speculation.
Thank
That's
you.
not a speaking objection. That's
So-
an objection.
Ma'am, what did you understand could be done with the numbers that identify the security cameras that would compromise or prejudice the physical security of the jail?
Same objections.
I believe that we discussed that, correction, when we met in our administrative meeting, we discussed the security of the jail for those concerns. Anyone that's ever been an inmate in the jail would know perhaps the number of that camera. I don't know. But it was a concern. And it was, weighed out. And we felt that that was an exemption that was necessary to maintain that security.
So, have you been through the jail?
Not recently, but yes, I have.
Do you know, do the cameras in the jail, do they have the numbers printed on them?
At one time, I believe they did. I don't know if they do today.
So at least at one point, the inmates who were in the jail would know if there's a camera in the corner, they'd know the number of the camera, right? Is that a yes?
Yes.
Okay. And your position is that if you disclosed the numeric identifier for a particular camera, someone could use that numeric identifier in a way that would impact the security of the jail.
That was one thought, yes.
Can you articulate for me how someone wanting to compromise the security of the jail would use the numeric identifier to do that?
Objection. Foundation. Calls for the witness to speculate.
I couldn't speculate on that.
Well, before you relied upon this exemption, did you or any of the people involved in the decision come up with or articulate any ways that a person could use the numeric identifier to compromise the physical security of the jail?
Objective foundation.
Yeah.
Go ahead.
I don't recall that, no.
Okay. Did you take notes at these meetings?
No.
So the best evidence we have of what happened at these meetings is your recollection or the recollection of other people, correct?
Correct.
There's no audio recording of the meetings?
No.
No video recordings of the meetings?
No.
Any follow-up emails or notes about the meetings?
No.
So you've told me that you determined that this information could be used to compromise the physical security of the jail, right?
Correct.
Did you do anything else after you made that determination before you decided whether to apply the exemption that relates to the physical security of the jail?
We met with the prosecuting attorney's office and they upheld our concerns, and that was the only meeting we had regarding that.
Prior to issuing the denial on that basis, did you engage in a balancing test?
I've just object to the form and foundation. If you understand it.
I think that we did, and all the times that we discussed it.
Okay. What do you think, when you engage in a balancing test under this exemption pursuant to FOIA, what receives more weight at the outset? Security of the jail, public interest in knowing, or are they the same?
Object to form and foundation.
I think that we considered both, and I think in this case, the public expects us to keep security. And so I would say that the security of the jail won out.
Did you prepare any affidavits related to your denial of Mr. Williams' FOIA request?
No.
Have you ever prepared an affidavit related to a FOIA request?
I don't believe so.
So it's your belief that you never, in supporting a denial, have prepared an affidavit explaining your reasons or the facts that would support your denial. Is that fair?
Asked and answered. Go ahead.
Yes.
Thank you. Why didn't you prepare an affidavit in this case explaining the reasons upon which you relied for the exemptions you claim related to Mr. Williams'
Objection
FOIA
foundation.
request?
Sorry. Go ahead.
I have, I believe that what was there was fine.
Has anyone ever told you that affidavits are required to support your claimed exemptions?
Objection foundation calls for legal conclusion. Go ahead.
It calls for a legal conclusion whether anyone's ever told her that?
Whether it's required.
I asked if anyone had ever told her.
Same objections. Go ahead.
No.
Did you ever explain, not in an affidavit, but in some other way, to Mr. Williams, the basis, the factual basis on which you relied for the exemptions?
Object to the foundation. Go
I
ahead.
provided the response and that was all.
The 2-page response?
Correct. And I believe,
Sorry.
and our office, Nathan Elger, also provided the appeal letter.
With regard to Freedom of Information Act requests for the jail, have you ever released documents containing the numeric identifiers for security cameras?
No.
There exists video from within the Grand Traverse County Jail on the day Mr. Holloway died, correct?
I believe so, yes.
Well, you received it from the jail, right?
Yes,
You
yes.
preserved that, haven't you?
Yes, yes.
Okay, so you still have physical possession of video of Mr. Holloway dying, correct?
I have not viewed the video, but we have preserved the video. That's,
So you didn't review the video before you denied the request?
I did not.
Do you know who reviewed the video, if anyone?
I'm sure the mission team, Michigan State Police, Captain Ritter.
Okay, so Mission Team and Michigan State Police, were they involved in your denial of Mr. Williams'
No.
FOIA request?
No.
Okay. Captain Ritter was?
Yes.
Anyone else that was involved in the denial that you know of who's reviewed the video of Mr. Holloway's death?
Under Sheriff Elger would have reviewed it, I'm sure.
Okay. So, you didn't cite it in your notice of denial, but was security of the jail the reason you didn't release the video of Mr. Holloway's death by hanging?
Yes.
How would you know, if you haven't watched the video, that releasing it to Mr. Williams would impact the physical security of the jail?
When we met as an administrative group, that was one of the concerns. I had not viewed it, but I know Captain Ritter and the majority of the group there had.
Do you know what's depicted in the video that captured Mr. Holloway's hanging death?
Objection foundation. She testified she hasn't seen it.
No.
Go ahead.
No.
Okay. Have you seen video from that video camera in that cell before?
No.
Have you seen video from video cameras in any of the cells before?
No.
You've never seen jail video from inside any of the cells?
Asked and answered.
No.
Okay. You're familiar with the requirement under FOIA that you separate exempt and non-exempt information, correct?
Yes.
And so, for example, if a video was 2 minutes long and 1 minute of the video was exempt information, you would be required to provide the 1 minute that was not, correct?
Objection. Foundation.
I'm not sure I understand your
Do you understand?
question.
Yeah, let me rephrase it, thank you. Do you understand that if a public record contains information that is subject to disclosure under FOIA and information that is not subject to disclosure, you have to give the requester the part subject to disclosure?
Yes.
Are you aware that if a video contains a portion that is not subject to disclosure and a portion that's subject to disclosure, you have to give the portion of the video that's subject to disclosure?
Objection. Foundation.
If that was the case, yes.
Okay. Yeah, right now I'm just asking
Okay.
not about these videos because you haven't seen them, right?
Right.
I'm asking about your understanding of processing
Yes.
FOIA.
Yes.
Okay. Similarly, if not a portion of time is exempt, but rather a portion of the video screen that's depicted, a portion of the image captured, if that's subject to exemption under FOIA, you understand you have to redact that portion of the image that was captured, correct?
I understand that.
Okay. And you have the ability to redact videos?
I believe we do.
Do you know if anyone reviewed the video with an eye towards redaction? The videos from inside the jail, that is?
I believe Under Sheriff Elger would have.
As you understand the basis for exempting the videos, how would having released the video of Mr. Holloway hanging impacted the physical security of the jail?
Objective. Foundation. Form of the question. Go ahead if you can.
It's still video inside the jail.
So is it your position then that no video from inside the jail can ever be released?
Not in this case. I don't believe it would be proper to do that. I think it's still security in the jail.
Can you help me understand what you mean by not in this case?
I've never had to view video in the jail, so I don't have anything to reference. I don't believe that it would, whatever the subject is on the video, if it's within the jail, it's still within the jail and is a security issue.
And so it would be the position of the Grand Rapids County Sheriff's Office that no video from within the jail gets released under FOIA.
Objection. Foundation.
I wouldn't say that. I think it should be reviewed and determined, but I'm not aware of any policy that says that. But as the FOIA coordinator, in this case, I think it's security in the jail.
Okay. What could somebody do with the video of Mr. Holloway hanging that would impact the ability of the sheriff to keep physical security of the jail?
Objection. Form. Foundation. Calls for speculation. Go ahead.
Again, it's not the subject that's in the photo being Mr. Holloway. It's the fact that it took place in his cell in the jail.
Okay. And what about that would impact, as you understand it, the sheriff's ability to maintain physical security of the jail?
Same objections. Go ahead.
Again, I can't answer what other people may do, but I think that it's a place that needs to be kept secure, and I don't think it's like having house keys, but you don't give them to everyone. I think it needs to be kept secure for the people out, the public on the outside and the public inside.
When you say it needs to be kept secure, do you mean the video needs to be kept secret or private?
I don't think it needs to be released.
Okay. During your discussions with Mr. Forsyth, or Captain Ritter, Under Sheriff Alger, all the people you talked about with regard to releasing the video, Was there ever any discussion about the things people could use the video for?
Again, I think it was just understood that that was a concern, but no, I don't think we specifically said it could be this or that.
Okay, so there was no discussion about what use might be made of the video that could be harmful to the physical security of the jail.
No.
And when you say it was understood, do you mean like in a common sense sort of way?
Yes,
Okay. But it was never overtly discussed.
not that I recall.
Was there ever any discussion in your conversations with Mr. Forsyth, Mr. Cooney, Sheriff Bensley, Under Sheriff Alger, or anyone else about the likelihood that Mr. Williams would file a wrongful death or 1983 lawsuit related to Mr. Holloway's death?
No, I don't believe so. I had not heard anything like that.
Do you think the public has any interest in knowing what occurs inside the jail?
I'm just going to face an objection to Foundation. I don't know how she can testify as to what the public would want, but you can answer that if you can.
I think they have a general interest, sure.
Okay. Do you think the public has a right to know what's going on in the jail?
Same objection.
Sure,
Do you think your job as FOIA coordinator requires balancing those rights?
I do.
What did you do in order to balance those rights here with
Objection.
regard to the videos
Objection to the
that you-
form. Sorry, go ahead.
that you withheld pursuant to the physical security exception?
Objection to the form.
I think I've already answered.
Indulge me.
Objection to the form of the question.
Can I have the question again?
What did you do prior to denying the request for the videos based on the physical security exemption to FOIA to balance the public's interest or right in knowing what occurs inside the jail with the jail's interest in maintaining physical security of the jail?
I considered what the public would want to know, what we as the sheriff's office need to do to keep it secure for the public that's on the outside and on the inside, and it was weighed in that way.
When you say what we as the sheriff's office need to do to keep it safe, what is that you need to do in order to keep it safe?
Objection form to the misuse of the word safe. I think she said secure, but
I'm sorry, did you say secure?
I believe so.
Okay. When you say what we need to do to keep it secure, what do you mean?
Whether or not we show where the cameras are or the video inside the jail, inside the walkways, inside the cell, wherever, I don't think that's part of what should be released. I think that is a security issue, or could be a security issue if it's released.
Okay. And you reach that conclusion without actually watching the video or ever looking at video from within a jail cell?
I did not see the video myself.
And you've never seen video from within a jail cell, right?
I've never had an opportunity to.
Is there a reason why you didn't provide an affidavit explaining how you thought releasing the video would impact the physical security of the jail?
object to the Foundation.
I didn't provide one because I think everything is there, or I thought everything was there.
And when you say was there, I just make a record, I want to be clear. You're talking about your 2-page September 8 denial, correct?
In the response, yes.
Okay. I'm not picking on you when I do that, but
It's fine.
we've got to have, you nodded at it. We all knew what you were talking about, but it doesn't show up in the written transcript. Have you ever released booking videos from the jail?
Yes.
Those are videos taken inside the jail, right?
Yes.
They show movement and behavior of people inside the jail.
No, they're just a headshot of someone in jail,
That's a booking photo. Let me back up.
Okay.
I think you misheard my question.
possibly.
Booking videos. Have you ever released videos
Oh.
from the booking area?
I have not.
Have you ever released videos of a subject taking a data master breath test?
I have not.
Do you know, does anyone else at the sheriff's office handle FOIA requests for the jail?
No.
So if they've been released since March of 2015, it would have been by you?
Yes. They
And-
do, let me say, they do take mugshots at the jail and release them. But other than video or video, no.
Yeah, I understand that.
Yeah,
I'm just,
okay.
right now I'm only talking about videos.
Yeah.
And my question is, if somebody had requested the booking video or data master breath test video from within the jail since March of 2015, that would have been handled by you.
Yes.
And so you're saying it's never been released.
I have never released it. I don't know if if the request didn't get to me somehow, then I wouldn't have any knowledge of that, but I have not.
Okay. You do release booking photos, though,
Yes.
and those are headshots, mugshots, essentially,
Yes.
of subjects that are arrested and lodged at the Grand Traverse Jail. Correct?
Correct.
So you also, I think, have testified here that one of the bases for exempting an item, strike all of that. Let's try this again. You testified here that you withheld the jail floor plan pursuant to the same physical security exemption, correct?
Yes.
Have you ever released that any other time?
Not that I'm aware of.
You've never released the jail floor plan pursuant to FOIA?
Asked and answered.
I just,
No.
thank you. Showing you it's been marked for identification as exhibit number 1. Do you recognize that?
Just placing a foundation objection to it.
Well, I asked if she recognized it.
It says that it's the jail first floor plan.
Okay. Have you seen that before?
This was included in your exhibits.
Before that, have you ever seen it?
I don't believe so.
Do you have any idea where I got it from?
No.
Object to foundation again.
Well, I mean, the question, do you have any idea, is a yes or no. If you do, I'd ask what it is, but you
No.
don't.
I don't know where you got it from.
Okay. Do you know if that was released by your office in response to a FOIA request?
I have not released that.
So, if you had, back up, for purposes of this question, let's assume that that floor plan is the floor plan of the Grand Traverse County Jail, first floor. If you had released the camera numbers, would that identify for us where on the floor plan the cameras were?
I don't know.
Would, okay. Is there anything inherent in a camera number that would identify its physical location within the jail?
Object to the form.
I don't know.
What information would the camera number convey to a person?
How many there are? Possibly if you had additional information where it's located would be
Okay.
my thought.
When you say additional information, you mean if you knew where it was located.
Yes.
But the camera number doesn't convey.
No, if you had been in the jail and seen it, you certainly would have that additional information.
Well, but if you had been in the jail and seen the camera, you'd know where the camera was, right?
Yes,
That's not information that's conveyed through the number, right?
right.
Are there any written policies at the jail or the sheriff's office with regard to release of video recordings?
Foundation. You can answer if you can.
I don't know.
Okay. You're not aware of any.
I'm not aware of any.
You don't deal with any in your role as a FOIA coordinator, correct?
Correct.
So as far as you know, there are none that impact whether to release or not, correct?
Correct.
For the recordings that you withheld under the physical security exemption, were there any audio recordings that went along with them?
Yes.
And how were the audio recordings captured?
I don't know that. I wasn't there.
What I guess I'm trying to ask, so let me rephrase, are these audio recordings that are captured along with the surveillance camera video, like there are microphones throughout the jail?
I don't know that.
Did you listen to them?
I did listen to some.
Okay, what did they seem to be recording?
The audio that I listened to was an interview, I believe, with a nurse. And that was, I believe that was provided to Mr. Williams.
Okay. And I'm talking about the things that were not released based on your claim of the exemption that it would impact the physical security of the jail. Were there any audio recordings?
Those were the only recordings I listened to. I'm not aware of any others for the security.
So some jails have essentially microphones throughout so they can listen to what's going on and record it. Do you know if Grand Traverse has that?
I have never heard that we do. I don't believe so.
All of the subject of Mr. Williams' FOIA request you still have maintained somewhere at the sheriff's office.
Yes.
Do you know physically where that's at?
Yes.
Where is that?
It's in administration.
Is it under your control or someone else's control?
Mine.
Okay. To your knowledge, has the jail, administration, sheriff, anyone who has authority over the jail allowed video recordings within the jail?
Foundation.
Have they allowed
Yeah.
of any kind?
Yes.
Well, on a daily basis, there is recordings, so I'll say yes.
Fair.
I,
Other than those captured by the sheriff's office through the security cameras, have they ever allowed video cameras to come through?
they may have, I don't recall.
Would you agree that whether video recordings are already available to the public might impact your claim that another video recording would impact the security of the jail?
Objective form foundation that calls for a legal conclusion. You can answer to the extent you can.
I believe if there were video from outside individuals taken at the jail, that it would be in areas that were a public area or that could be observed by the public.
What does that mean, a public area?
If you could, you can't so much now, but previous years before the remodel, they were, there was a reception desk with windows across the wall, and you could see into the control room. So you certainly would have a public's view of that, and they may allow that.
So, but let me phrase it this way. In your role as a FOIA coordinator, in determining whether or not to release something, is your decision informed at all by whether the subject matter or document is already in the public domain?
Objective form and foundation. You can answer.
Yes.
Because if something's already out there, there's no reason to try and keep it a secret,
Right.
right? Okay. And you don't know whether there are any video or still pictures from within the jail in the secure areas that are already in the public domain?
I don't know.
If you knew that there were, that might impact the decision you made.
It certainly would have been a point of discussion, sir.
want to talk about the frank communication exception, okay? Do I understand correctly that the only items that were withheld were emails between Captain Ritter and his subordinates?
I believe so.
Did those emails go both ways?
I believe so.
What was the subject matter of the emails?
I believe it was addressed in Under Sheriff Elger's response to Mr. Williams' appeal, if I recall, it may have been maybe disciplinary type information. It was correspondence between him and his officers.
So let me see if I understand. How many corrections officers were on the receiving end of his... Strike that. Who sent the first email that you're exempting under frank communication?
I don't recall.
Was this a discussion started by the undersheriff, by Captain Ritter, or was this started by the corrections officers, or don't you know?
I don't know.
Was it a discussion, when you said, it was a discussion about disciplinary matters, was it trying to learn more about who to discipline? Was that what it was?
I believe so.
So Captain Ritter was sort of investigating what to do
Yes,
and trying to learn more about what had happened so he could make the right
to
decisions.
gain information.
Is it fair to say then that Captain Ritter sent out an email at some point requesting information from people? Or requesting details from people?
At some point, I don't know if it was an email request, but I would assume that that request was made.
And then people replied or responded to him in some way?
Correct.
The responses came via email?
Yes.
And those responses included information about what had happened?
I believe so, yes.
And then also probably their opinions about what had happened?
Yes.
Did you actually review these emails before determining that they were exempt?
Yes.
Did anyone else review them before determining they were exempt?
Captain Ritter, I believe under Sheriff Elger as well.
Did you attempt to separate the exempt and non-exempt information within these emails before issuing your denial?
I believe we just withheld the entire thing for those.
I would agree that you did withhold them. My question is, did you attempt to separate the exempt and non-exempt information first?
No.
Why not?
I think everything, all of it would have been exempt. It wasn't.
Is the date of the email an advisory piece of information?
Objective foundation.
I don't know. I assume it could be.
Okay. Do you think it's advisory information who sent the email?
Same objection.
Yes, it could be.
What information, what advice is contained within the sender's name?
I'm not sure I understand what you...
Explain to me how you think that providing Mr. Williams the name of the sender and the date that the email was sent would disclose communications of an advisory nature.
I don't believe that that was considered. I think that we identified that the attachment was not what, we were not going to release that, and so the entire email was not included.
So you said the attachment, there was an attachment to the email?
In some cases, sure.
So in some cases there was an email that said, hey, look at this attachment or something along those lines?
Yes.
If you had disclosed to Mr. Williams the email and the reference, look at the attachment, would that have disclosed a communication of an advisory nature?
Foundation.
No.
You didn't separate
I
those
didn't.
items. Do you remember what the subject line, without telling me, do you remember what the subject line of the emails was?
No.
I assume you don't know, but I'm going to ask anyway. Do you know then whether the subject line contained a communication of an advisory nature?
Objection foundation, go
I
ahead.
don't know.
Okay. It's possible that the subject line might have just been something generic, correct?
Object to speculation.
It's possible.
If the subject line was something along the lines of Holloway and nothing more, that wouldn't communicate anything of an advisory nature, would it?
No.
If the emails contained a reference to the fact that Mr. Holloway had died by hanging, that would not be information or communication of an advisory nature, right?
Correct.
That would just be a factual piece of information, right?
That's correct.
Because he died by hanging.
Correct.
These emails contained some factual information, like Mr. Holloway died by hanging.
If that was what was included in there, I don't recall, but yes, if it was, it would.
Well, the attachments in the emails talked about the events that occurred on the day Mr. Holloway died, correct?
Object to the foundation.
Not all of them, I don't believe, but they may have. I don't know.
To the extent that they talked about those factual details, Mr. Williams would be entitled to receive those, correct?
Objection to the foundation.
Sure.
Is that a yes? But the Grand Traverse County Sheriff's Office didn't separate those factual things from the advisory things, correct?
Same objection, foundation.
Correct.
You've been trained that you're required to separate the exempt and the non-exempt.
Yes.
Why didn't you do it here?
I think that it was not done. It was I guess just not considered to be of value. And if that's why we exempted it. That's why we didn't include it.
So, the frank communication emails, were those also discussed at the two meetings, the one without Forsyth and the one with Forsyth?
They may have been. I don't recall specifically.
Did you engage in a balancing test prior to determining that you weren't going to disclose the so-called frank communication emails?
Just like the other information, yes, we did.
Explain that for me, please. What do you mean, just like the other information?
Like the security of the jail information.
But what facts did you take into consideration, or what policy concerns did you consider before making your decision?
We considered that it was disciplinary in some cases. It was information pertaining to that, and that it just would not be included.
With regard to the decision to exclude those emails, was there any discussion about potential civil liability?
No.
You said you made the determination that it just would not be included. Did you consider the public's interest in seeing the information?
I'm sure we did, but it was a personnel issue, and we didn't include it.
You said it was a frank communication, right?
Right.
And you're saying you didn't include it because you decided not to include it. And that, would you agree that's a little bit of a circular explanation?
Sure, yes.
Can you point to any specific facts that you relied upon in concluding that you shouldn't disclose it rather than you should disclose it?
The information in the email was not factual. It was a conversation between the captain and his supervisors. I think it fell under frank communication. It wasn't a factual thing. It was, they were still communicating about things that were possible or possibilities or things like that. It was nothing factual.
I see. Now, for the first time you said it was between the captain and his supervisors. I thought it was between the captain and his subordinates.
Yes, his sergeants is what I was
Okay.
referring to. His supervisors within the jail.
The people below him that report to him.
Correct.
Do you believe when you were considering whether to release frank communications and you're doing the balancing test that the public has a greater interest in disclosure than the government has in non-disclosure? Or do you think they're equal? Or do you think the government has a greater interest in non-disclosure?
Same objections.
I think they're equal. I think it depends on the subject.
So you think in frank communications the interests in non-disclosure and disclosure are equal and you weigh them?
Yes,
And that's what you did here?
correct.
Do you know either exactly or approximately how many public records, emails, were withheld under the frank communication exception?
I don't know how many.
Do you know if it's less than 500?
Oh, yes.
Do you know if it's less than 100?
Yes.
You know if it's less than 10?
That would be my guess.
Less than
Yes,
10?
Less than 10.
Okay. If you had, were most of these emails short, 1-2 pages?
Yes.
So we're talking about no more than 10 or 20 pages of documents.
I believe so.
There was a request for copies of all contracts or agreements entered into by Grand Traverse County and the sheriff or jail that are in any way related to any contracted or employed medical, psychiatric, or psychological professionals who were working or had contact with Mr. Holloway during his incarceration around the time of his death. Do you remember that part of the request?
I do.
Okay. There didn't appear to be a direct response to that in your FOIA response. Do you know why that is?
I believe there was an agreement in there for community mental health.
Do you know if the sheriff's office has a contract with, and maybe this is the same entity, but Northern Lakes Community Mental Health?
It is the same, and I'm not certain. I believe that there's an agreement that they do services at the jail, but that's the extent that I know.
Do you believe you provided that to Mr. Williams in response to the FOIA?
I can't recall.
Can you think of any reason why that would be exempt from disclosure?
No.
If we didn't get it, would you provide it in response to a FOIA request now?
I would think so.
So you also denied a request for the names of inmates who provided witness statements relating to the death of Mr. Holloway, correct?
Correct.
You did this because you said it would be an unwarranted invasion of personal privacy,
Yes,
because it would disclose the identities of people incarcerated and or arrested or convicted of a crime.
correct.
And to do that, you relied upon the personal privacy exemption that's found in FOIA.
Correct.
That's the one that says information of a personal nature, if public disclosure of the information would constitute a clearly unwarranted invasion of the individual's privacy, right?
Yes,
And so you think it would be a clearly unwarranted invasion of an individual's privacy for the public to know that the person had been incarcerated
I do.
or convicted of a crime
Yeah.
or accused of a crime?
Yes.
So is it, at least as it pertains to FOIA, the position of the Grand Traverse Sheriff's Office that folks accused of crimes or convicted of crimes should have privacy in that fact?
Yes.
And that people incarcerated within the jail should have that fact kept private?
Yes.
You release booking photos, right?
We do.
That sort of identifies that somebody's been in the jail, right? Mm-hmm. Is that a yes?
Yes.
Pretty clearly identifies it, right?
Yes.
In fact, your office sends out press releases.
They may. I don't do those.
You've seen press releases from your office.
Yes.
And those press releases identify people in the jail, right?
That they have been charged with a crime. Yes.
And that they've been arrested and lodged in the jail, right?
Correct.
In fact, your office also maintains a Facebook page.
Yes, I believe they do.
You've seen the Facebook page.
Yes.
And someone from the sheriff's office posts details of people arrested and charged with crimes on the Facebook page.
Yep.
Is that a yes?
Yes.
Thank you. You understand that one of the interests the public has with regard to people accused of crimes is in knowing who the criminals are, right?
Correct.
Public has a right to know who's committing crimes. Is that a yes?
Excuse me. Yes.
In fact, you're aware that crimes are prosecuted in the name of the people of the state of Michigan, right?
Yes.
Because you understand that when a crime's committed by someone, it's committed against all of us, right?
Sure. Yes.
And we all have a right to know who the criminals among us are.
Yes.
So why then couldn't Mr. Williams know the names of the people in the jail?
I'm going to object to the form in the foundation.
That's fair.
Your question
I'll rephrase.
assumes that everybody in the jail is a criminal. Go ahead.
Do you know, does the sheriff's office generally arrest people that they believe not to be guilty of crimes?
I'm going to object. Same objection.
No, we don't.
Okay. So it would be generally understood by the people at the sheriff's office in the jail that the folks in jail are criminals, right?
I'm going to object.
That's fine.
It's a misstatement of fact. Go ahead.
I don't look at it in that manner. Sorry.
The people within the jail are all accused of crimes, right?
Correct.
Or they've been convicted.
You have to
Yes.
answer verbally.
Yes. I can hear me.
I know. And so these people that are in the jail have either been accused of crimes by the government or convicted of crimes by the government, right?
Correct.
And the sheriff's office distributes that information in other contexts, correct?
Correct.
Why do you think it's a clearly unwarranted invasion of personal privacy then to tell Mr. Williams the names of people that were in the jail on the day Mr. Holloway died?
I still think that the other inmates are people. Their privacy, this is an unusual situation. I think that their privacy needs to be respected, and I think it's could lead to be an embarrassing thing. And the only thing that was redacted in that information under that exemption were names of the inmates, but their activities and everything else in the jail, the information is provided in the logs.
Do you believe that a name is personal or public information?
I'll object at form of the question.
In
You can
this,
answer.
in this case, I think it is a private thing.
You think the person's name is private in this case? Why this case? What's different about this case from any other case?
Because you're not telling the general public that this individual is accused of something. In this instance, just because they're in the jail, yes, they may be accused, but they still have a right to privacy, and I don't think they need to know that they went to the medical office for the day or they, did something else. I just think that that's private.
Maybe I factually missed something. Was Mr. Holloway in the medical office at the time he died?
No.
Okay. How would giving me or Mr. Williams the names of people that provided statements disclose that they had been to the medical office?
I don't think that it would. But there were other logs that had names redacted that showed movement throughout the jail, whether it was visitation or medical appointment, whatever. And that's what I was referring to, was that information. In witness statements, the entire statement is there. The information is there.
But the name isn't, right?
Correct.
Now, are you familiar with something called VineLink?
I've heard of it.
Heard of Mobile Patrol?
No.
You're aware that there are websites that list people within the Grand Traverse County Jail, correct?
I'm not aware of any. I don't.
What did you think VineLink was?
I thought VineLink may be a source for a victim to know if a suspect is released or transferred or something of that nature.
Have you ever been to the VineLink website?
No, I have not.
I want to address your comment about the log showing movement. You said that showing the person's name would tell us, for example, that they had sick call, right?
Yes.
You could have just redacted person went to the medical office to protect that person's privacy, right? And left their name?
I suppose, but
That would have resulted in far fewer redactions, right?
I think it would have required more time. It would certainly catch my eye. A name would catch my eye closer than the action.
Yeah, and I didn't ask about time. I asked about how many redactions would be required. On the movement logs, most of the people weren't going to a place where they had a privacy interest, right?
Some were.
Most weren't, right?
I'll object to the foundation of that.
I don't know the number. I don't know if it was less or more.
In any event, if you had redacted the names on the movement log, but not on the witness statements, that wouldn't disclose anything about the person's medical issues, right?
Correct.
The only thing it would disclose is the names of the people who witnessed something that happened at the jail. Yes?
Correct.
Do you believe that the public has the right to exercise oversight on its elected officials, including Sheriff Bensley?
Yes.
Do you believe that they have the right to do that through Freedom of Information Act requests?
I think they have the right to obtain whatever information they are seeking.
Do you think that a citizen has the right to distrust its government and want to verify information?
Yes.
By redacting the names of the witness statements, would you agree that it impacts a citizen's ability to ask the person who allegedly gave the statement if it's accurate?
Object to the foundation. Go ahead. If you know.
No.
Is there any way, if I wanted to go ask one of the people who gave the witness statement? If it's true, is there any way for me to figure out who gave the statements?
Not from the FOIA request, there is not.
In some of the inmate interviews, you redacted more than the name, correct?
I recall maybe an address or something like that. Is that correct?
You can only answer to the extent that you know, so.
Yes.
You provided the mission team the Sheriff's Association report, correct?
Yes.
And you did the redactions in that report as well?
I did not.
Who did the, sorry,
Captain Ritter.
did you review his redactions?
I did.
Are you aware that he redacted from the mission team report the entirety of some inmate statements?
I didn't recall that. No.
Can you think of any basis in your notice of denial that would support the redaction in its entirety of an inmate statement?
I wasn't aware that the entire statement was redacted.
One moment, please. When did Captain Ritter make those redactions?
It was after we met with the prosecutor's office, and I was present. The two of us were together.
Why was that delegated to Captain Ritter?
I don't know.
Well, was it delegated to Captain Ritter?
I believe under Sheriff Alger asked him to do that.
Okay. Have you seen the Sheriff's Department's answer to our complaint in this matter?
No, I have not.
Go ahead and flip through the whole thing. For the record, I just showed her your answer and I think affirmative defenses.
I have not seen it.
Okay. Did you consult with anyone prior to, or excuse me, subsequent to our filing the lawsuit about how the county should respond to the lawsuit?
No,
Or how the sheriff's office should respond to the lawsuit?
no.
Okay. Give me one moment. When you received the documents responsive to my client's FOIA request, were you provided with a copy of the booking video of Mr. Holloway?
No,
Do you know if that's been preserved?
I do not know.
I'll pass the witness.
I don't have any questions. Thank you.
Thank you.
We're all set.
We're off the record. The deposition is now concluded. The time is 11:51 p.m. and we're off the record.